Good morning. Welcome to another installment of Environmental Essentials for In-House Counsel. I'm Brittany Pemberton. I'm a partner in Bracewell's Washington, D.C. office and in the Environment, Lands, and Resources group. And I'm joined this morning by my partner, Jeff Holmstead. So we're going to be discussing EPA's proposed repeal of the carbon pollution standards for power plants and spending some time explaining the agency's rationale as well as the implications of the rule for the rest of industry. Just one little housekeeping note. You may know that in the last week or so, EPA sent a proposal to repeal the 2009 endangerment finding to the White House Office of Management and Budget. Not going to cover that in any real depth today, but I'm sure you'll hear more from us once that proposal actually becomes public. Turning to power plants, on the 11th of June, EPA issued a proposed repeal. Comment period is 45 days long, so you've got until August 7th to weigh in on the proposal if you're interested in doing that. The proposed rule actually has two different proposals in it. A primary proposal that would repeal all current Section 111 greenhouse gas standards. So that's going back to the Obama administration, the NSPS that was issued in 2015, as well as a 2024 rule that the Biden administration referred to as the carbon pollution standards. And that's the one that everyone's familiar with because it included the requirement to have carbon capture and sequestration installed with 90% efficiency. So the rationale for that primary proposal is that greenhouse gas emissions from fossil fuel-fired power plants don't significantly contribute to dangerous air pollution. In the alternative, EPA has proposed to repeal really just the most burdensome parts of the 2024 rule, which is chiefly, as I mentioned, that 90% CCS, as well as co-firing 40% natural gas. And that's based on what it has now determined is achievable, adequately demonstrated and cost-effective under the statute and what meet energy requirements, which is one of the factors that goes into determining what the best system of emission reduction really is.
So let me just chime in here quickly and highlight what we think maybe the big issue is for industry. I think Brittany will explain this in a bit more detail, but EPA's primary approach, basically reversing the endangerment findings for power plants, is legally pretty risky for reasons we'll talk more about. And I think that if they finalize it as proposed, there's a very good chance that it won't stand up in court. The alternative approach, on the other hand, is very strong, and I think would almost certainly be upheld, assuming there's a good rulemaking record for it. In terms of protecting the power sector from incredibly costly requirements, if I had to choose one or the other, I would certainly choose the alternative approach. But the administration has made it clear that their priority is to reverse the endangerment finding. And I think in doing that, their hope is to prevent a future administration from coming back and reimposing these standards. So at this point, EPA has proposed these as two alternatives. There's been some talk that they might try to find a way to finalize both of them so that if the primary proposal is not upheld, at the very least, the requirements that require carbon capture and sequestration or require some coal-fired plants to co-fire with natural gas, that at least those would go away. The problem is, logically, that's hard to justify. If they finalize the primary proposal and revoke all the CO2 standards for power plants because their CO2 emissions don't contribute significantly, and you're confident that those will stand up in court, there's really no reason to also finalize the alternative. If they were to try to somehow finalize both, with the alternative being a backup plan, it certainly makes the primary proposal look weak, but it also probably makes the alternative approach more vulnerable to a legal challenge. So I think the risk for industry is that if they go with the primary proposal that gets potentially or likely struck down in court, then the CCS and the co-firing requirements would spring back to life or could. And so I think that's strategically the big issue for industry and certainly the power sector, but other sectors of the economy as well.
So to unpack the primary proposal a little bit, I think it's always good to start with the text of the statute, just as a reminder to everybody. So Section 111B actually endows the administrator with the authority to include a category of sources in, a list under the statute for regulation if, in his judgment, that category causes or contributes significantly to air pollution that may reasonably be anticipated to endanger public health or welfare. And that language contributes significantly is a big part of EPA's interpretive approach to what it's doing in the primary proposal here. But there are a couple of other statutory interpretive issues that are important to the proposal, sort of as a threshold issue. And the outcome that EPA is trying to reach under the primary proposal really depends on these two holding up. And one of those is that in order to list a source category under Section 111 for regulation, EPA has to make a pollutant-specific finding as opposed to just, making a finding, maybe decades ago and being able to regulate the entire source category going forward on the basis of a finding that's unrelated to the, pollutant issue right now. And the other issue is really a change in approach from what was done in prior administrations going back to that 2015 Obama era NSPS. That administration basically took steam generators as a source category and stationary combustion turbines as a source category and put them together as a single fossil fuel fired power plant source category for purposes of, considering significant contribution under Section 111. So, those two threshold issues, I actually think EPA has done a good job on the proposal here, and that they're likely to be upheld in court is really the best reading of the statute. Jeff, any thoughts that you wanted to add to those points?
No, I think that's right. If you go back to that prior slide, the language is a bit awkward because it says, the question is whether EPA should list a category. And EPA says, well, if we list a category because we've previously found that it causes or contributes to dangerous air pollution, then once it's listed, the listing is done and we can regulate any pollutant we want. That's been EPA's historic position. But I do agree with you that I think the best reading of this language, and really the only one that makes sense in the context of the statute, is to say before EPA can regulate a pollutant from a source category, they need to find that emissions of that pollutant from that source category significantly contribute to dangerous air pollution. So I think they're on solid grounds there. And I think sort of the alternative, which is to say, well, if you combine two source categories, you have a new source category and you need to make a finding for that. So I do agree with you that I think they're on very solid grounds there.
So then I guess turning to what I think critics in public have already noted as being problematic about the primary proposal and what would put it on shaky ground, sort of as an optics perspective, it's hard to argue that a source that's as large as 3% of global emissions is not a significant contributor, even if emissions from the U.S. power sector have fallen in the last 20 years. I think that's sort of one issue that probably is going to loom large in the comments and will probably be argued at least as an atmospheric approach, no pun intended, in litigation over the primary proposal. But then really when it comes to how EPA is interpreting significant contribution, the agency seems to be reading a lot into the idea that this is left to the judgment of the administrator, and they have proposed that there would be a number of factors that EPA should consider when they make the significant contribution finding, like whether, controls that are available are cost effective and achievable, and would they make a dent in the problem at issue? And of course, with the global and, kind of well mixed in the atmosphere nature of greenhouse gas emissions, that's a real question. But the big one really is leaning heavily on the administration's policy priorities, basing the administrator's judgment of significant contribution on current policy preferences. I think some people would argue violates Loper Bright Resources v. Raimondo. That, as everybody knows, that opinion overturned Chevron deference as a doctrine and really makes it the auspice of the courts to determine the best reading of the statute. And so the argument there is, while Loper Bright certainly leaves some room for courts to defer to an agency's reasoned determination, when there's language in the statute that denotes some discretion, and I think we have that here in that use of the word judgment, a court may question whether the best reading of the statute allows EPA to put substantial weight on policy preferences, especially when those policy preferences may cut against, sort of the overall purpose of the statute.
Yeah, and the other problem I think they have is this the same basic language appears in 6 different provisions of the Clean Air Act when EPA is called upon to make a determination as to whether a pollutant or a source category significantly contributes to air pollution or to dangerous air pollution. Those provisions have always been read to be purely a scientific question. They don't really have anything to do with how EPA regulates. But the question is, well, whether they can regulate a pollutant or regulate a source category. I mean, the language just says, does this source category contribute significantly to air pollution, which may reasonably be anticipated to endanger public health or welfare? And then once they make that finding, they consider all sorts of things, including their policy preferences and the costs and other things in determining how to regulate, not whether to regulate. So, Brittany, as you and I have discussed, one of the things the Supreme Court certainly mentioned in Loper Bright was a contemporaneous interpretation of the statute, especially one that's been in place for many years, is not definitive, but it's certainly indicative that that's the interpretation that is likely to be the best interpretation of the statute. So EPA is, I think they have an issue with the language of the statute itself, but also just with the history of how not only this provision, but other similar provisions have been interpreted for many years.
Another point that I've seen raised in the public domain, Jeff, and I'm curious for your take on this one, is whether Massachusetts versus EPA actually prohibits these types of policy considerations. In deciding whether the Clean Air Act authorizes EPA to actually regulate greenhouse gas emissions, the Supreme Court didn't reach the issue of whether policy concerns could inform EPA's action in the event that it made an endangerment finding, under a slightly different part of the Clean Air Act on remand. But it did explain that any policy preferences EPA might consider can't be, and this is a quote, divorced from the statutory text, because Congress's choice of the word judgment is not a roving license to ignore the statutory text. Do you think that argument has some purchase here?
I do. It certainly, Massachusetts versus EPA can be distinguished because the question was different. But as you pointed out, the court said that policy preferences of an administration can only be taken into account when that's consistent with the statutory text. And, here, they've relied pretty heavily on the term judgment and saying that is a capacious term that gives discretion to the administrator to consider, many things, including policy preferences.
And the policy preferences that they're invoking here really relate to the president's big picture agenda of energy production, energy dominance, and security, where EPA has proposed, in the primary proposal here to conclude that those are issues that are essential to the public health and welfare, and therefore they can be, grafted into this consideration of significant contribution.
Right. And those certainly do seem to be important implications for determining how to regulate. But the question of whether emissions from the source category significantly contribute to dangerous air pollution, it's certainly not read very naturally to include those policy considerations. I will also point out that much of what they point to as a rationale for making the finding of no significant contribution, they involve impacts that they believe would flow from that finding. What would a future EPA do if they were to regulate under this section? And we already had a DC Circuit case when the original endangerment finding was challenged in the DC Circuit. The petitioners in that case argued that EPA had erred by not considering the impacts, and the court said that EPA had not, and in fact certainly suggested that EPA couldn't consider those things. They needed to look at the scientific questions. So I think they have an issue with the language of the statute, with the history of the interpretation, and with the DC Circuit case. But to me, the most puzzling thing about all this is even if that finding, or even if the reversal of the finding by the Obama administration that power plant emissions do significantly contribute to dangerous air pollution, even if that were to be upheld in court, by relying so heavily on the discretion of the administrator and his or her policy preferences, it seems like it would be pretty easy for the next Democratic administration to come along and say, our policy preference is to reduce greenhouse gas emissions and to help encourage the rest of the world to reduce their greenhouse gas emissions too. So, to the extent that their hope is to prevent sort of future regulatory overreach, I don't think this really accomplishes that, because if their rationale is upheld, the same rationale could be used by a future administration to say, upon further review, upon reconsideration, we do think that the emissions contribute significantly. So I think in some ways that's the most surprising thing, that in trying to justify their finding that it does not significantly contribute, they seem to have left the door open to a future administration to come along and reach a different conclusion.
So I guess, turning to the question of what does this mean for the rest of industry? If you're not in the power sector, what do you take from all of this? I think first and foremost, we have to think about the oil and gas methane standards, the so-called Quad-O, ABC, that suite of rules that's been back and forth in between administrations in terms of approach and what's being regulated in terms of segments of the industry and the pollutants as well. EPA has already promised to reconsider all of that. And the question really is, what are they going to do in light of this Section 111 power plant proposal? It's hard to see how they wouldn't make a similar argument in terms of significant contribution. If the power sector doesn't significantly contribute, and it's the second largest source of greenhouse gas emissions in the U.S. behind transportation, why would it be that the oil and gas industry significantly contributes? So I think that the statutory, interpretations that they've laid out here, in terms of needing a pollutant-specific approach, the factors that we've been talking about, they would certainly want to apply all of that to oil and gas sources. The wrinkle that they're certainly going to have to work through is the question of what would they revert back to. People who have followed the methane rule drama over the different changes in administration will remember that when the Trump administration came in the first term, they actually issued a rule that rolled back part of the Obama administration's regulations on methane emissions from the oil and gas sector, and basically reverted to regulating only VOCs, and they took out, part of the sources that were regulated as well. But that rule got overturned by a Congressional Review Act disapproval resolution, which means that EPA now is going to be barred from issuing something to regulate those same sources that's substantially similar. And so the question is, what would be the end result that they could reach here that wouldn't be substantially similar? I don't know the answer right now. I hope to spend some time thinking about the answer of that, because I think it's going to be an important issue. But it's certainly going to be something that EPA has to wrestle with, and that will end up being litigated. People who follow the CRA may also know that judicial review is pretty restricted under that statute. But the issue of what is substantially similar appears to be one that courts could take up. So I think that's going to be a feature in the discussion for Quad-O regulations, and something that ultimately will end up before the DC Circuit.
The other issue for the oil and gas industry will be really the same one that faces the power sector today. If the agency uses the same rationale and determines to eliminate the methane regulations because those emissions don't significantly contribute to dangerous air pollution, that not only has a potential problem with the CRA, but has the same problem that we've been talking about with the primary proposal here, that it certainly seems to be legally vulnerable. And if they were to rely entirely on that and then have that determination overturned by the DC Circuit, that means that the methane regulations would spring back into place, unless they somehow have a primary and they also have a fallback. But that is, legally problematic too. So I think there is this tension between the desire of the administration, in the famous words of Administrator Zeldin, to drive a dagger through the heart of climate religion. That seems to only be possible if they reverse one or more of the endangerment findings. And yet we know that is a legally risky strategy. And I think I'm not speaking on behalf of any particular clients, but I think industry is very interested in having a sound rule that explains why the requirements, certainly in the power sector, are contrary to the statute, because the requirements have not been demonstrated as adequately demonstrated and achievable and cost effective. And the same thing would likely come up in the context of the methane regulations, where if those regulations are not reformed to make them more reasonable, the industry could be facing a very costly set of requirements coming back into place. So both for the power sector and I think for the oil and gas sector, there are some interesting legal and strategic issues that the industries are going to have to deal with.
And I'll also say that, EPA has announced that it intends to take some reconsideration action on the various tailpipe emission standard rules as well. And I think we've talked about this before when we did our webinar on the endangerment finding, that Section 202A of the Clean Air Act actually sets a slightly lower bar for regulating greenhouse gas emissions from those sources, because the statute doesn't use that word significantly when it looks at the cause or contribute finding. It just says cause or contribute, not cause or contribute significantly. So, everything that we've been talking about here in terms of EPA's rationale about what is significant contribution, they're going to have to take a different approach, I think, when it comes to vehicle emissions. But the fact that they've sent over to the White House that proposal on the endangerment finding, and it's actually, the way it reads on the White House website is that it's paired with reconsideration on vehicle rules. We don't know what that means exactly at this point in time, but if EPA revokes the finding that greenhouse gas emissions don't threaten the public health and welfare altogether, then, that would certainly set them up to much more easily repeal the car rules than they otherwise would be able to do if they live with that scientific finding and then have to just look at cause or contribution.
Well, I suspect that maybe after that rule is made public, we'll have another opportunity to have this conversation. But I did want to make just one last point, particularly about the power plant rule. My own view is that the Biden administration's determination that carbon capture and sequestration has been adequately demonstrated, taking costs into account, I think that faced an uphill battle in the courts. I think that there's a good chance that would have been overturned. And I think that this administration could do a very good job of putting some meat on the bones of what adequate demonstration means. There is some very early D.C. Circuit case law on that, but I'm not sure that those interpretations would today be viewed as the best interpretations of the statute. And I think that there are ways that a robust EPA rule explaining why CCS has not been adequately demonstrated, and in part based on the geographic differences of the availability of, and I mean, to some extent, we've seen those discussions already. But one of the things that I've always thought about is, Section 111 rules are meant to be sort of the floor, not the ceiling. And NSPS standards have to be achievable throughout anywhere in the United States. And the idea that, even if you could demonstrate that CCS had been demonstrated in a certain location where you had immediate access or a pipeline would be very different for power plants built in other parts of the country where the cost differential would be enormous. And I think EPA could establish, I don't want to say standards, but establish an approach that would codify sort of under Loper Bright what the best interpretation of those statutory terms are. And I would certainly hope that that's what they would do in a final power plant rule, both with regard to CCS and with regard to co-firing. And I do think they've done a very good job of that in their alternative proposal. But I would like to see them flesh that out a little bit more. Brittany and I thank you for taking the time to listen to us today. These are obviously issues that are of enormous importance to the power sector, but I think also important to other sectors that are either currently regulated or could be regulated for their greenhouse gas emissions under Section 111. Obviously, there will be much more discussion. The comment period closes relatively soon. And I think once people have a chance to review the comments and think more about this, there will probably be more to discuss. And then fairly soon, we will see the presumably a proposed revocation of the 2009 endangerments finding, which is likely to present a whole group of other issues.
Well, that's all we have time for this morning. So, as always, this has been an interesting discussion, and there are a lot of live legal issues, as you can see in the power plant proposal. The comment period for this, as we mentioned at the outset, closes August 7th, and based on sort of the average amount of time that it's taking the Office of Management and Budget to clear proposed rules through the interagency review process, we may also have an endangerment finding proposal, even before August 7th. We'll see. So please stay tuned for future announcements of additional webinars, on this series, as I think there's certainly going to be more for us to talk about.